At 6:47 this morning, President Trump signed Executive Order 14392, dissolving the United States Court of Appeals for the Ninth Circuit, effective immediately. The order transfers all pending cases to other circuits, reassigns all 156 federal judges to non-judicial positions within the executive branch, and establishes a new judicial structure under direct presidential oversight. This has never happened in American history. No president has ever attempted to dissolve a federal appeals court. Within 90 minutes, 156 federal judges issued a joint statement declaring they will not comply. Subscribe to this channel immediately. This is a direct confrontation between the executive and judicial branches over whether a president can eliminate courts that rule against his administration. Turn on notifications, because the next 72 hours will determine whether federal courts can be dismantled by presidential order or whether judicial independence survives its most direct assault in modern history. Executive Order 14392 opens with findings that the Ninth Circuit has issued 47 rulings blocking executive actions on immigration, environmental regulation, and national security. It claims these rulings represent judicial activism threatening executive authority. The order invokes Article 2, Section 2, claiming presidential appointment authority implies power to restructure courts when they obstruct executive functions. Section 3 is the operational core. All 156 judges are reassigned to advisory positions within the Department of Justice without judicial authority. All pending cases transfer to the 5th, 8th, and 10th circuits. A new Western Judicial District is established, requiring only majority Senate confirmation rather than the traditional 60-vote threshold. Hit that like button right now. A president just attempted to eliminate an entire federal appeals court that ruled against him. What is being documented is an executive branch attempting to restructure the judiciary to eliminate opposition. At 8:14 a.m., 156 federal judges did something unprecedented. They issued a joint statement declaring the executive order unconstitutional and void. Released simultaneously to every major news organization, the statement is 3 paragraphs and unequivocal. The statement reads, "The judges of the United States Court of Appeals for the Ninth Circuit have been informed of Executive Order 14392. We declare this order to be without constitutional authority and void ab initio. Article 3 of the Constitution vests the judicial power of the United States in courts established by Congress, not the president. The Judiciary Act of 1789 and subsequent legislation created the federal circuit courts. Only Congress has authority to restructure or eliminate these courts. The president's claim that Article 2 grants him power to dissolve courts is without precedent or legal foundation. We will continue performing our constitutional duties. This court remains in operation. We call on all parties in pending cases, all federal employees, and all law enforcement agencies to recognize that this executive order has no legal effect." That statement was signed by Chief Judge Mary Margulia and every other judge on the circuit. It represents a unified judicial branch response to an executive branch power grab, and it creates an immediate constitutional crisis because 2 branches of government are now claiming contradictory authority. The president says the Ninth Circuit no longer exists. The judges say they are still operating and the order is void. At 9:23 a.m., the White House doubled down. The statement declares the order lawful and warns that judicial defiance constitutes obstruction, potentially resulting in impeachment referrals to Congress. At 9:47 a.m., the United States Marshals Service issued an internal directive instructing marshals to take no action to enforce the executive order. Marshals will continue providing security at Ninth Circuit courthouses and treating judges as federal officers entitled to protection. The Marshals Service is standing down. Drop a comment right now. State whether federal judges can defy a presidential executive order. Every response is being tracked. The mathematics reveal the scale. The Ninth Circuit covers 9 states and 2 territories: Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, Washington, Guam, and the Northern Mariana Islands. That is 20% of the geographic United States. The circuit has 29 active judges and 127 senior status judges. That is 156 total judges. Every single one signed the defiance statement. That is 100% unified judicial opposition. The Ninth Circuit hears approximately 6,000 cases per year. That is 16% of all federal appeals. Transferring these pending cases to other circuits would overwhelm those courts and delay justice by years. Tens of thousands of litigants would lose their right to appeal. Subscribe to this channel right now. What is about to be shown is how other institutions are responding and whether enforcement mechanisms exist to resolve the standoff. At 10:34 a.m., the Senate Judiciary Committee announced an emergency hearing at 2 p.m. today. Chairman Dick Durbin called the order an unprecedented attack on judicial independence. He stated that only Congress has authority to dissolve federal courts under Article 3 and that the hearing would examine possible impeachment. Ranking member Lindsey Graham called for negotiated resolution rather than immediate impeachment. The split suggests partisan division with some Republican discomfort. At 11:02 a.m., the American Bar Association, representing 400,000 attorneys, called the order a direct violation of separation of powers and existential threat to judicial independence. The ABA announced it would file an amicus brief in any legal challenge. Within 30 minutes, 23 state attorneys general announced a joint lawsuit in the Northern District of California seeking an immediate injunction. At 11:47 a.m., Chief Justice John Roberts issued a rare statement. The independence of the federal judiciary is a foundational principle. Article 3 vests judicial power in courts established by Congress. Any action purporting to dissolve or restructure courts without congressional authorization raises grave constitutional questions. The Supreme Court stands ready to hear any case that properly comes before it. The statement signals Roberts views the order as constitutionally problematic, and the court will likely strike it down. Here is what is being monitored over the next 24 to 72 hours, because 6 indicators will reveal how this constitutional confrontation resolves. Indicator 1. Does the president rescind the executive order before legal challenges reach federal court? If the order is withdrawn within 24 hours, it suggests the White House legal team concluded it cannot survive judicial review. If the president doubles down, it signals intent to force a Supreme Court showdown. Indicator 2. Do any Ninth Circuit judges comply with the executive order and cease judicial functions? If even one judge acknowledges the order's validity, it fractures the unified judicial response. If all 156 judges continue hearing cases, it demonstrates complete judicial defiance. Indicator 3. Do federal agencies comply with the executive order or continue recognizing Ninth Circuit authority? If the Department of Justice, FBI, DEA, ATF, and other agencies stop appealing cases to the Ninth Circuit and treat the court as dissolved, it enforces the president's order. If agencies continue filing briefs and appearing before Ninth Circuit judges, it means the executive branch itself is divided. Indicator 4, does the Marshals Service maintain its stand-down posture or receive direct orders to enforce the executive order? If marshals are ordered to prevent judges from entering courthouses or to block judicial proceedings, the crisis escalates to physical confrontation. If marshals continue protecting judges and facilitating court operations, enforcement of the order becomes impossible. Indicator 5, does the Senate Judiciary Committee vote to begin impeachment proceedings? If the committee votes along party lines with all Democrats and no Republicans supporting impeachment articles, it becomes a partisan issue unlikely to result in conviction. If multiple Republicans vote to advance impeachment, it creates pressure on the president to back down. Indicator 6, does the Supreme Court agree to hear an emergency appeal on an expedited basis? If the court grants certiorari within 48 hours and schedules oral arguments within a week, it signals the justices view this as a constitutional crisis requiring immediate resolution. If the court declines to intervene or delays proceedings, it allows the standoff to continue. Here are 3 scenarios for how this crisis resolves over the coming days. Scenario 1 is the retreat scenario. The president, recognizing the order cannot be enforced without marshals' cooperation and will be struck down by the Supreme Court, rescinds it within 48 hours. The White House claims the order exposed judicial activism, but alternative methods will be pursued. The Ninth Circuit declares victory, the crisis ends, but underlying tension remains. This is face-saving de-escalation where the system worked but revealed judicial independence's vulnerability. Scenario 2 is the legal showdown. The president does not rescind. The 23 state attorneys general file suit. A district judge issues a restraining order. The Ninth Circuit upholds it. The Supreme Court grants certiorari and rules 6-3 or 7-2 that the order is unconstitutional. The president complies. This is the constitutional system working through courts with judicial review successfully checking executive power. Scenario 3 is defiance. The president refuses to comply after courts rule against him. The Department of Justice stops recognizing Ninth Circuit rulings. Federal agencies ignore Ninth Circuit orders. The judiciary issues rulings, but they are not enforced. The United States operates with a shadow judiciary where courts issue decisions the executive branch ignores. This is constitutional collapse where separation of powers breaks down. Turn on notifications right now, because when the Senate hearing begins at 2 p.m. Eastern, when the lawsuit is filed, when the Supreme Court responds, the analysis will be posted immediately. Which scenario unfolds depends on decisions being made in the White House, the Justice Department, the Senate, and the Supreme Court over the next 72 hours. Let the historical context be examined. The federal circuit courts were created by the Judiciary Act of 1789. Over 234 years, Congress expanded the system to 13 circuits. No president has ever attempted to dissolve a circuit court by executive order. Franklin Roosevelt in 1937 proposed expanding the Supreme Court to overcome conservative opposition, but never attempted to dissolve existing courts. Richard Nixon, during Watergate, considered defying Supreme Court orders, but complied when advisors warned of immediate impeachment. Even Trump, who criticized the Ninth Circuit repeatedly, never issued an order attempting to dissolve it. What is happening today is beyond any precedent. Article 3, Section 1 states, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." Congress creates federal courts. The president appoints judges with Senate confirmation, but cannot create or dissolve courts. Article 1, Section 8 grants Congress authority to constitute tribunals inferior to the Supreme Court. The Judiciary Act of 1789 exercised that authority. Every subsequent judiciary restructuring has been through legislation, not executive order. Executive Order 14392's claim that Article 2 grants implied authority to restructure courts has no basis in constitutional text, precedent, or historical practice. The question at the center is whether constitutional separation of powers can be enforced when the president claims authority the Constitution does not grant. The judiciary declared the order void, but courts have no army, no enforcement mechanism beyond public acceptance and executive agency cooperation. If the president orders the Justice Department to ignore Ninth Circuit authority, if agencies refuse compliance, if marshals are ordered to prevent judges from holding court, the judiciary cannot compel compliance except through impeachment. And impeachment requires 2/3 Senate conviction. If partisan loyalty prevents conviction, a president who defies judicial authority faces no consequences. Here is what is certain. At 6:47 a.m., the president signed an order dissolving the Ninth Circuit. At 8:14 a.m., 156 judges declared it void. At 9:47 a.m., the Marshals Service declined to enforce it. At 11:47 a.m., Chief Justice Roberts defended judicial independence. At 2 p.m. today, the Senate holds emergency hearings. Within 24 hours, 23 attorneys general file suit. Within days, the Supreme Court will likely rule on the most direct executive assault on judicial authority in modern history. The next 72 hours will answer whether the United States is a nation where courts established by Congress cannot be dissolved by presidential decree, or whether constitutional limits only exist when a president chooses to respect them. When the president claims authority to dissolve courts, he claims a power the Constitution does not grant. Whether that claim succeeds depends on whether Congress, courts, and agencies resist or comply. Stay with this channel. When the Senate hearing concludes, when the lawsuit is filed, when the Supreme Court acts, analysis will be posted immediately. This is a president testing whether judicial independence can survive direct executive assault. The answer will define whether American democracy includes enforceable separation of powers, or whether constitutional limits are only suggestions that determined presidents can ignore.